Greetings, this is the Florida Populist channel with Jeff J in Tampa Bay, where it's sunny and warm and never the norm. We emphasize local Florida, city, county, and state politics and law as it relates to economic freedom, individual liberty, and following the Constitution. District of Criminals, go home! Let us alone! Just real quick, so Florida has always been the butt of many jokes, you know, by the highbrow intellectuals, those sophisticated, or those from up north, like, oh yeah, well, we don't do it like you guys do in Florida, you know, all that, all the jokes. And, you know, now with COVID, everybody's moving down here, so who's joking now? Now that the fake stream media can't rag on Trump anymore, they get to rag on DeSantis, right? And we were the perfect thorn in their side because, you know, we've seen extreme pandemic restrictions. Let's say government response to the pandemic, those restrictions just basically have the same or even worse results than Florida that has less restrictions. So that just doesn't fit in that tidy little box. Anyway, of the blue anons in the media, Florida is also now on the cusp, or I would say at the forefront of being victorious in, I guess we could call it pandemic mitigation law, with Jeff Childers at the helm, attorney Jeff Childers. He won a case at the District Court of Appeal level, first DCA in Florida, Green versus Alachua. It should be required reading for every American. It's a great opinion. Even the dissenting opinion is good to read. It was a 2-1. It was a 3-judge court. And they ruled 2-1 in favor of the plaintiff, Green. So that's the only case like it in the U.S. So Florida, we're pioneers of that, thanks to Jeff. And recently, and this is what I'm going to focus on, is the Gainesville case. City of Gainesville wanted to impose a vaccine mandate on their employees. And so I won't say they won, because it was an injunction. They filed for a temporary injunction pending the city having to respond. So, but as it stands right now, that case was on September 20th. So as it stands now, there's a temporary injunction in place pending Alachua answering. And so they can't impose the vaccine mandate on city employees. So I'm going to focus on Jeff's closing argument. It's a case friend that was and a whole bunch of other employee. I think it was like almost 200 employees, but one of them was, I think, Daryl Friend. But the case is Friend versus City of Gainesville. Alachua County Circuit Court, that's the 8th Circuit Court. Alachua County Circuit Court, 8th Circuit. Here's the case number 2021-CA-2412. And I'm going to focus on his closing argument. It is powerful, very, very brilliant arguments. He does what I think is legal AIKIDO. He takes the City of Gainesville's argument, right, and he just throws it back in their face and just buries their head in the floor. It's amazing. And I like his loose writing style. I guess in the legal world, they might consider his delivery colloquial. That is, it's kind of informal, not in that dry legalese that you would expect to hear in a Supreme Court opinion or whatever. But I like his style. It's almost like how he writes it in his blog. And by the way, Jeff's website is Coffee and COVID, all lowercase letters. Just spell the word coffee with 2 F's and 2 E's. Coffeeandcovid.com. Got to check it out. Brilliant man with brilliant insights into, I guess we could call it COVID 1984. Anyway, I want to get into Jeff's closing argument for Friend versus City of Gainesville, Alachua County 8th Circuit Court, 2021-CA-2412. Here we go. May it please the court. The plaintiffs are asking the court to immediately enjoin the city's new vaccination requirement until their claims can be tried. I'm going to divide my argument into 2 parts. In part 1, I'll frame the issue to be decided. In part 2, I'll explain the simple, straightforward 5-step legal analysis that requires this court to grant the plaintiff's injunction today. It's not even close. I will now begin addressing part 1. Part 1, the city's property rights. The city thinks that its employees' bodies are its property. And since the city can do whatever it wants with its property, it can do whatever it wants with its employees' bodies. Farmers routinely fully vaccinate their herds of farm animals. It's a commercial necessity. You can't have some of those animals getting sick or even spreading disease around the herd. Those animals are valuable. They cost money. You can't afford to lose a few to some cow virus or something. The reason that kind of herd vaccination is uncontroversial is because the farmer owns the cows. Those cows are the farmer's property. He can do whatever he wants with his property. Those cows don't have any right to bodily autonomy, right up to and including death. Their bodies are the farmer's property. He can inject anything he wants into them. The city owns buildings that have air conditioning systems. If a new ultraviolet technology comes out, the city can install it into their HVAC systems if it wants to, whenever it wants to. Nobody's going to complain about that. The HVAC systems are the city's property. Those ultraviolet lights might kill germs and save the city some money by reducing sick days or something. Now, there's a new vaccine technology. The city wants to install the new vaccine technology into its employees, just like it can install ultraviolet lights into its HVAC systems, because they are its property. It can do what it wants with its property, especially if it saves money. Does this sound hyperbolic? It's not. The city makes this argument throughout its opposition brief. The city even says in its brief that, while it's crass, the justification that overrides all arguments would be some unquantified and unquantifiable savings to its self-insurance plan. We need to look no further than the capstone of the city's opposition, its concluding sentence, the sentence that summarizes and encapsulates the city's entire previous argument. Let me read to you what it says. Quote, "In the words of George Washington, upon ordering the mandatory smallpox inoculation of colonial troops in 1777, quote, necessity not only authorizes but seems to require the measure. For should the disorder infect the army in the natural way and rage with its usual virulence, we should have more to dread from it than from the sword of the enemy," end quote. Continuing, George Washington, your first thought, like mine, is that the city has a pretty high opinion of itself. It thinks it is just like our first president, George Washington, the brilliant general who won the Revolutionary War. But once I started thinking about it some more, I realized the city is right. It is like George Washington. George Washington in 1777, just like the city said in its brief. So here are a few things you probably didn't remember, like I didn't, about George Washington in 1777. In 1777, George Washington was the supreme commander-in-chief of the Continental Army, which was then fighting the British. That was 11 years before we had a constitution, which wasn't ratified until 11 years later in 1788. 1777 also was 11 years before we had a Supreme Court. 1777 was also 10 years before we even had a president. See what the city is saying? They think they're like George Washington, a supreme military commander in 1777, a decade before the U.S. even had a constitution or a court to argue about it in. In other words, the city thinks it is just as free from pesky constitutions as George Washington was in 1777 when he was ordering all those soldiers to get a primitive form of vaccination right before ordering them to charge up the hill into oncoming musket fire. The city thinks it's George Washington. I thought about it some more. Do we have any idea what George Washington might have thought about issues like bodily autonomy? And I realized that, yes, we do have some idea. We know exactly what the city's avatar, George Washington, thought about bodily autonomy. I don't mean this to be critical. George Washington lived in a different time with different cultural norms. But George Washington owned people. He inherited his first 10 people when he was 11 years old and went on to buy and own hundreds more. He grew up with the idea that people could own people and do whatever they wanted with them. His employees were his property. They had no bodily autonomy. What a silly idea. He owned their bodies. Later in life, he even took their teeth to make his own dentures. Their bodies were his property. George Washington looked at his employees as being the same as farm animals. You had your herd of farm animals, and you had your herd of employees. You had to manage those herds. You had to keep them healthy. You had to vaccinate them. You don't ask the herd how it feels about being vaccinated. Herds are just dumb animals who don't know what's good for them. You have to make your herds get vaccinated, compel them, in other words. Now, the city is going to rush to argue, hey, we're not making anybody do anything outside of work. This is just a work thing. It's an on-the-job requirement, just like wearing a uniform. You want to work here? You have to wear a City of Gainesville polo shirt at work. It's exactly like that. And that is exactly what George Washington would say. But the city's argument is nonsense. It's nonsense because you can take the polo shirt off when you go home, but you can't take the vaccine off because it is making permanent changes to its employees' bodies. Changes that endure beyond the workplace, all the way beyond. Changes that follow the employees into their homes and their private lives. Changes that follow the employees to the next place of their employment and ultimately to the grave. In his lengthy dissent in Green, side note, I'm going out of script here. Green is that Green versus Alacho case that Childers won regarding the government. The holding was that government mask mandates are presumptively unconstitutional. Okay, continuing. Jeff Childers' closing argument. In his lengthy dissent in Green, Judge Lewis made this very point as he was discussing the temporary nature of compelled mask wearing. You only have to wear the masks at work. Judge Lewis said, quote, the fact that the mask mandate does not infringe on a person's private or home life further indicates that it does not implicate Florida's right of privacy. Florida's right of privacy guarantees the freedom of a person to control his own body. End quote. Continuing. Unlike the mask mandate at issue in Green, which Judge Lewis firmly felt did not interfere with a person's private or home life, the city's vaccine mandate absolutely doesn't interfere with an employee's private and home life. Of course it does. So listen to what Judge Lewis said next. Quote, the mask mandate is not compelled medical treatment, and the wearing of facial covering does not alter one's physical person. Rather, the mask mandate is a temporary and de minimis interference with a person's public interactions, end quote. Well, Judge Lewis couldn't have said it any better. He said the mask mandate is just a, quote, temporary interference, end quote, when you're in public. It's not like it's compelled medical treatment or anything. Then, Judge Lewis made sure to point out the inescapable truth that face masks don't alter one's physical person, but vaccines do. They alter employees' physical person by definition. So, what are we to make of the city's argument that, quote, hey, we aren't bound by the Constitution, end quote. The city says we can do what we want with our employees, our property. It's a pretty simplistic argument. In 1777, George Washington wasn't bound by a constitution. The city thinks, writing in its brief, that it's like George Washington. So the city isn't bound by a constitution either. The city thinks it has the authority of a pre-constitutional supreme military commander. Remember, one possible side effect of the vaccines, however rare, is death. Just like George Washington could order his soldiers to their deaths, the city believes it can require its employees to potentially take one for the team. Come on, be a team player. You know, you can't make an omelet and so forth. George Washington didn't respect bodily autonomy. He thought his employees were property. The city doesn't respect bodily autonomy either. And it also thinks its employees are its property. But, fortunately, Florida law says no. District of Criminals, go home. Let us alone.